So we'll go to the next slide. So Charlie, this is our Visa Bulletin for employment-based category 1 through 5. So any comments you want to make on this? This is final action date.
Yeah, just there is a lot of green in this chart, and which is a very positive thing for any applicants awaiting so they get their cases finalized. And my only concern with the rapid movement is most of these dates for China and India, second and third preference, have moved at least 4 months, as much as 5.5. My concern is making such rapid advances early in the year could lead to potential need for either holding the dates for an extended period of time in the coming months, or at some point having a corrective action in terms of a retrogression. I might, given the fact that they were coming off of or at the time the dates were determined, they were still in the government shutdown, didn't know how long the November shutdown may have lasted. I may have been a little hesitant to advance the dates for December until I really saw, okay, what impact did our or advance of the dates in October, what impact did that have? Was it what we expected? And then they had plenty of time beginning in January to advance the dates at that point when they had a clearer picture to maximize number use. And again, one of my concerns is that based on the rapid movement during the first quarter, I think they could easily use up to 40% of the annual limit in the employment second and third for both India and China.
So when Charlie's talking about the fiscal year, we always have to remember that the government's fiscal year starts on October 1 and ends on September 30th. So we're actually in the first quarter of the government's fiscal year, correct? And you mentioned something about the government shutdown. So Michael, is the USCIS impacted by the government shutdown? Were there employees who were not working, or were they actually adjudicating adjustments during this 45-day-ish time period?
Yeah, no, great question. The USCIS, as I guess everyone knows, is funded by the fees that applicants pay. And that, throughout my career, exempted me from shutdowns. So while my neighbors had that week off, I don't think they felt great about it, but I went to work. So USCIS kept working during this shutdown, kept adjudicating. There's a small portion of the agency that doesn't do adjustment or visa use work that is appropriated, and I'm not sure what happened to that team, but adjudications continued going on all throughout.
Okay, so Charlie, Department of State also still was working, right?
Correct. As Michael said, state, the consular affairs is essentially fee-based, not dependent on appropriations. But the one thing is, the overseas posts, their first priority is American citizens. So if they did have any type of staffing reductions or limitations, the first priority would go to the overseas citizens, and they may have to shift some staffing around, and that would be just the concern. I wasn't hearing of large amounts of appointments being canceled, et cetera. And I know, as Michael said, there were adjustment of status cases being processed. Unfortunately, we don't have any real visibility into such number use, so it's hard to say was there a negative impact or any impact on number use during October and the first part of November.
Okay, and then Joey, do you want to mention anything about the EB-5 unreserved set-aside?
The set-aside visa categories remain current since their existence, so people can file their EB-5 case and adjustment through the end of the year, which is wonderful. It was great to see some forward movement for India and China in the unreserved category, and we just need to see more numbers be used, right? And so that's the big thing. We got adjustments that can be adjudicated starting December that couldn't be before. We got interviews at consulates that can be rescheduled that before had been canceled. So there's a lot of great things that are happening in December for EB-5.
Okay, so this is Chart A, and then we move to Chart B. So this is the dates for filing. So Charlie, do you want to explain the Chart B?
Again, typically sometime in the middle to late August, I would consult with the service center operations and we would kind of look at the estimated annual limits in employment for the next year, how many were going to be available worldwide and on per country limits. And then we would look at the amount of demand that we already knew about that was pending, ready for action. And if, for example, we knew that we needed to use 100,000 numbers and we only had 50,000 applicants that we knew of at that time, then we would advance the application dates to generate another 50,000 applicants so that we could by the end of the year, we could maximize number use. And again, and that's just those two figures are just to use easy examples. And again, they would generate the demand. So if say for China, the date for October was going to be, say, May or January 1st of 2023, they would say, okay, we think that the date by September would get to at least May 15th of 23. They would allow applicants with that Chart B to go ahead and file so that although their case may not become eligible for final action till April or May or whatever, once it did, it would be ready for immediate final action. Prior to October of 2015, when USCIS started imposing the Chart B, the applicant would have to wait until their Chart A date had actually been reached. At that time, they could submit their paperwork, and it would be many, many months down the road before their case could be finalized. So this new procedure allows state to have much greater visibility into the amount of pending demand should they move the Chart A dates ahead.
So we have Michael here. So Michael, why don't we have you two talk about what you normally would talk about with Department of State and USCIS about how to determine Chart B and the dates for filing?
Sure. No, I think that's a great topic from my experience, right? That salary analogy that Charlie used is great, right? So if everything were perfectly predictable, the plan would be that you set the dates for filing, and then you'd move the final action dates slowly or at whatever pace gradually through the year, and you'd end up where you started, right, with the dates for filing and the final action dates being the same, or at least you move it along so that due to the dynamic that Charlie just described, you'd always have enough of work in the queue to, on a regular, evenly basis, use all the visa numbers. What we do, what the agency does on a probably on a day-to-day basis, but certainly on a weekly and monthly basis, is watch the numbers. USCIS, I think, and y'all can correct me, is responsible for between 80 to 85% of the employment-based visa usage. Mm-hmm. So getting your sense of how many adjustment applications are pending and how many are likely to be approved is everything, right? And bonus if you know it by category and country, right? And so what I've seen over the past 5 or 6 years is USCIS has really upped its game and started using technology, and they have real-time dashboards that show what's available. And then, the smart people go to work and say, look at approval denial rates and look at what's documentally ready on the consular side and communicate all of that, have long discussions. Before, we used to just listen to what Charlie said and write down the answers. But since he left the scene, it's this collaborative process, but the data has gotten really rich and drives a lot of the process.
So basically what you're trying to say is the dates for filing date that you agree upon with Department of State that they're going to post is the anticipation that within an 8-month, 12-month time period, your agency or USCIS is actually going to approve or adjudicate those cases?
That's correct. Or enough of them to use all the visas. Absolutely.
Okay.